Two.
Hello, I'm Kenny Leigh of Kenny Leigh and Associates. I'm here with Nathan Kohley, managing attorney in our South Florida offices, and today we're going to talk about relocation. Nathan, what is the relocation statute, and how does it apply? What's it all about?
Well, it's essentially just a statute the legislature created to prevent one party relocating with the minor children more than 50 miles away from the other parent without at least getting permission or the court's permission.
Do you have that statute number for people who are watching?
Yes, it's 61.13001, and that statute governs relocation in the state of Florida.
Okay. What type of case does the relocation statute apply to?
Really, it's any case involving children, so it's typically divorces and paternity cases.
Okay, well, let's go specifically about paternity. Let's say a dad is on the birth certificate. Does the statute automatically kick in then?
No, just because you're on the birth certificate doesn't actually give you any paternal rights. You would need to petition the court to become paternal father. At that point, once you are paternal father, the relocation statute will generally kick in.
Okay, so if you're on the birth certificate and you are not married to the mother, what happens, you do not automatically have rights. That's a common misconception. You have to get judicially recognized rights for the statute to kick in. Is that right?
That's correct. And if you're married when the child's born, then you're automatically going to have those.
Okay, so it's automatic. All right. So again, the distance is 50 miles. How do they determine the location, the distances, like from point where to point where?
It's going to go by, well, if you've had a prior divorce and you have a parenting plan, it's going to go by the address on that parenting plan, basically the address you had when you got the divorce. If you're in a paternity case, it's going to be by the last address that you had when you filed that paternity action or when the last court order involving the children was.
All right, very good. All right, so let's say that you are the parent that wants to relocate with the child. What basically do you have to do?
Well, first, I always advise people to try to get the other side to agree in writing to it. If the other side agrees in writing, it's a very easy process where you'll file and you're going to already have an agreement. If the other side's not going to agree, you're going to file a petition with the court, which is then going to be served on the other party, and the court's going to generally have an expedited hearing and determine what's in your children's best interest whether the relocation can occur.
And what's key to this is, as you know, Nathan, is there are some very technical requirements on a petition to relocate. So if you do even the slightest thing wrong, the whole thing can be kicked out. All right. So let's say that the other party, the baby's mother or whatever, decides to leave with the child and doesn't comply with the relocation statute. What can we do then?
Well, generally, you're going to go forward on a motion for contempt. You're going to try to have the other party held in contempt for doing so. You're also going to ask the court to force the children back home, at least until the court can decide whether or not they're going to allow the relocation. But at that point, if you've got the contempt in place, you've got the ammunition you would need to try to prevent that relocation if you're opposed.
Okay, but we've all heard how busy the court system is. I mean, how quickly do you think we can get a hearing if they just leave the state?
These you can usually get moved on the docket pretty quickly because of the seriousness of it. When one parent has relocated with the children more than 50 miles, especially when it's an out-of-state issue, the court will generally let you move forward on the docket much more quickly than if this was just...
And I believe the statute actually says it's supposed to be expedited.
It's supposed to be expedited, yes.
Yeah, and of course, things that are supposed to happen don't always happen, but we certainly try to make them happen. Also, there are times when you can actually file an emergency motion based on relocation, but again, emergency motions are very difficult, and a lot of people think emergency motions are good when they're actually not. So, but there are times when the relocation can occur. All right, so let me see here. Are there reasons that would it help? Does it help you at all if somebody relocates with a child without your permission on a bigger scale?
Well, on the bigger scale, what you're going to use is you're going to use that to show the other parent is not very good at co-parenting, and they're not very good at involving you in the children's lives, especially if they're going to relocate without asking your permission or without any court permission and taking the children away. The reason the 50 miles is so important is because the courts and legislature have kind of determined that distance makes it more difficult to exercise that time sharing with your children. So,
okay, very good. All right, so again, Kenny Leigh and Associates, our firm exclusively represents men in the area of family law. If you want to learn more about this, please go to our website at divorcemenonly.com. Thank you.